Be ready. 5 seconds. Start. The President of India is the ceremonial head of State of India and the Commander-in-Chief of the Indian Armed Forces. The President is indirectly elected by an electoral college comprising the Parliament of India, both houses, and the legislative assemblies of each of India's states and territories, who themselves are all directly elected. Although the Article 53 of the Constitution of India states that the President can exercise his powers directly or by subordinate authority, with few exceptions, all of the executive powers vested in the President are in practice exercised by the Prime Minister, a subordinate authority, with the help of the Council of Ministers. The President is bound by the Constitution to act on the advice of the Prime Minister and Cabinet as long as the advice is not violating the Constitution. India achieved independence from the British on 15th August 1947, initially as a dominion within the Commonwealth of Nations, with George VI as king, represented in the country by a Governor General. Still following this, the Constituent Assembly of India, under the leadership of B.R. Ambedkar, undertook the process of drafting a completely new constitution for the country. The Constitution of India was eventually enacted on 26 November 1949 and came into force on 26 January 1950, making India a republic. The offices of monarch and governor general were replaced by the new office of President of India, with Rajendra Prasad as its first incumbent. The Indian Constitution accords with the President the responsibility and authority to defend and protect the Constitution of India and its rule of law. Invariably, any action taken by the executive or legislature entities of the Constitution shall become law only after the President's assent. The President shall not accept any actions of the executive or legislature which are unconstitutional. The President is the foremost, most empowered and prompt defender of the Constitution, Article 60, who has preemptive power for ensuring constitutionality in the actions of the executive or legislature. The role of the judiciary in upholding the Constitution of India is the second line of defense in nullifying any unconstitutional actions of the executive and legislative entities of the Indian Union. Under the draft constitution, the President occupies the same position as the King under the English Constitution. He is the head of the state but not of the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal by which the nation's decisions are made known. The primary duty of the President is to preserve, protect, and defend the Constitution and the law of India as made part of his oath, Article 60 of Indian Constitution. The President is the common head of all independent constitutional entities. All his actions, recommendations, Article 3, Article 111, Article 274, etc., and supervisory powers, Article 74 2, Article 78C, Article 108, Article 111, etc., over the executive and legislative entities of India shall be used in accordance to uphold the Constitution. There is no bar on the actions of the President to contest in the court of law. Legislative power is constitutionally vested in the Parliament of India, of which the President is the head, to facilitate the law-making process per the Constitution, Article 78, Article 86, etc. The President summons both the houses, Lok Sabha and Rajya Sabha of the Parliament and prorogues them. He can dissolve the Lok Sabha.